Hello everyone, a very good morning to all of you. Welcome to the CAIIB BRBL Chalisa. So let's revise all the module in a very quick way, okay? So in BRBL, as we know that there are 4 modules, okay? You can easily see that in 4 module we have in Module A 2 acts, Module B 4 acts, Module C 10 act, and Module D there are total 9 acts. So total 25 act is there in BRBL subject. Okay. Now a quick revision of Module D. So class, in Module D, the first is Indian Contract Act. So Indian Contract Act is basically, it's talk about, it is divided into 2 parts. The first is general principle of contract, okay, and the second part is spatial principle of contract. So general principle of contract is essential points of the valid contract, and spatial principle of contract, as we can see that this is your 5 terms that we have to understand. So essential points of valid contract is basically where 2 parties should be there in any contract. The party should be offered and offering. It's the party's name. There should, in the contract there should be the legal relationship between the parties. Exactly, suppose if we just take the example of house, so house is not the example of valid contract, because in house generally promises taken place. Okay, so in valid contract there must be a legal relationship between the party. Just always remember the formula of contract that is in the general principle of contract. Offer plus acceptance is equal to promise. Promise in legal term is equal to agreement. In agreement, when law will be in force, that is equal to contract. So this is the basic definition of the term contract. Is that okay? Now class, there should be there should be the fulfillment of the legal formalities. If we are doing a valid contract, so the formalities or the rules and regulations should be in the form of legal way. Okay. Then class, the meaning and the terms of contract must be clear and specific according to the contract. In the contract, the performance must be possible. In the contract, the performance must be possible. If we talk about the agreement, so contract must have the agreement, and that agreement must be the legal agreement, because agreement can be the social, domestic, religious, but in the Indian contract, agreement must be the legal one. Free consent agree, it means whenever the 2 parties are doing contract, the consent should be free. It should not be in the form of fraud, coercion, undue influence, misrepresentation. Then parties must be competent to contract. It means plus 18, sound mind, not disqualified by law. There should be lawful consideration, there should be legal object, and the contract should not be void and illegal. So that is a important points of the valid contract. Okay. Now if we talk about the special principle of contract, indemnity, section 124, the one word to remember is loss. Loss to the one person, protection of loss to the another person. All the example of insurance is contract of indemnity except life insurance. 2 parties, first is indemnifier, the person who give the protection, and indemnity holder and indemnified are the same person. It means the person who have taken the insurance is called indemnity holder. Okay. Contract of guarantee, section 126, there are 3 parties: surety, principal debtor, creditor. The principal debtor will take money from the creditor, okay, and when the principal debtor is not able to pay the money, the surety will pay. 3 terms, bailment, contract of bailment, section 148. So when one person deliver another person a thing, and that should be the for the specific purpose, and when the purpose is accomplished, the person can take back the things to the another person. Example, tailor. Example, parking. Okay, so if we are parking our car, or if we just see the example of bank, if I'm just keeping my jewelry in the safe custody, that is called bailment. Bank is bailee, Nikita ma'am is bailer. Okay. Contract of pledge, section 172. Contract of pledge, it means we are giving movable property as a security and we are taking the money. That is called pledge. Agency, section 182, contract of agency. There are 2 parties, agent and principal. So agent is a person who always work under the guidance of principal. That's it. Okay. So this is the complete Indian Contract Act. Just quickly revise whatever I have just shown. Please class. And if you have any doubt, you can please ask in a comment box also. Okay, I'm available in the comment box. Okay, so this is your Indian Contract Act. Okay, class. Now, the next one is your Indian Partnership Act. So, Indian Partnership Act, as you can easily see that partnership definition is given in section 4. Okay, section 4 talks about the Indian partnership meaning. Okay, section 4. So, partnership is basically, suppose these three are the partners in a particular partnership firm. Partnership firm, okay? So the partners collectively is called partnership firm. And what exactly the partnership means? It is basically the main aim is to do the business. Profit will be shared among all and loss will be bear by all the person. Types of partner, partnership by will, no time limit. Partnership, particular partnership, that is the partnership is made for the particular project. When the project is complete, partnership will be finished. And then partnership at a fixed period. So fixed period means suppose the partnership is made for the 1 year, 2 year, 3 year, etc. So this is called the fixed partnership. Okay. So there are three types of partnership. For the partnership firm, registration is not compulsory. So it is optional for the partnership firm to be registered or non-registered. If we talk about the negative impact on the non-registration of partnership, so the negative impact is that the first of all, the business will not impact, but in the non-registration of partnership, the partner cannot file sue against firm and partner. If suppose if minor become a partner, so first of all, minor cannot be a partner, but suppose if minor become a partner, so if he become a major, suppose now the minor become major, so he have a 6 month of time period in which he have to declare in the public notice that whether he want to become a partner or not to become a partner. So this is your minor as a partner. Okay, that is given in section 30. Suppose when the partner when the minor become major and he declare as a partner, so his liability will be arise when he is start taking benefit. So on that time period, the liability will be start. Dissolution of partnership, it can be either by the way of interference of court or by not interference of court. Okay, you can see dissolution means end of the partnership firm. Minimum 2 partner in partnership firm, maximum 50 according to company rule 2014. Okay, and according to company act 2013, the maximum is 100. So this is very much important. And the maximum and minimum number of partner is not written in the partnership act, but it is written in the Indian Company Act. Okay, so that's it. Now class C, the types of partner. So active partner who actively participate in the business. Sleeping partner who does not actively participate. Nominal partner whose name is only given. Okay, partner by estoppel, the person is not a partner, but the real partner introduce the person as a partner to the another person. Okay, partner in profit, he will take only profit, not for the loss. Minor partner, as we have already done this. Okay, so this is the Indian Partnership Act. Now class, sales of good act, there is a sale, there is an agreement to sale. Sale is basically that is a present sale. Okay, present sale means the seller have given the ownership of goods to the buyer and buyer have given the price, that is called sale. Agreement to sale is basically, if we say agreement to sale is a future sale. Future sale means the thing should be done at the future. Condition, it is also known as guarantee. So in condition, suppose if the buyer purchase the things from the seller, suppose if the buyer purchase the hot water bottle and that bottle is not according to that, so buyer have a right to just ask for the refund and the buyer can end the contract. But in warranty, there will be only the replacement of the item. So this is called warranty. Okay. Right of unpaid seller. Unpaid seller means the buyer have not given the full price. So right of unpaid seller is against the goods or against the buyer. If we talk about against the good, lien. Lien means seller can hold the goods till the full payment is not done. Suppose if the good is transferring to buyer, he will stop it. The buyer can also resell the goods. Okay. Right against the buyer, he can just end the contract. So file the case for the price, file the case for damages, that is compensation, and file the case for any interest if it is there. So this is your Sales of Good Act. Then class, if we talk about the company, so company, as we know that registration is very much compulsory if you are opening any company to the registrar. Okay. Types of company, there is a public company, private company, government company, holding company, subsidiary company, Indian company, foreign company, as you can easily see the name. Corporate wheel, company is a different entity and the members is a different entity. This is called corporate wheel. If a company is in debt, member is not liable because both are different entity. Memorandum of association is a important document. An article of association is also an important document. In memorandum of association class, there are 6 clauses: name clause, capital clause, object clause, register clause, association clause. Okay. Name, capital, object, register, liability clause. Okay, so there are 6 types of clause in the memorandum of association. An article of association is basically it's talk about the internal rules and regulations of the company, that is called article of association. Doctrine is a principle, doctrine of ultra vires. Company cannot do the things which is beyond the memorandum of association. So ultra vires means beyond the power, you cannot do anything. Constructive notice. Constructive notice is basically, suppose if the outsider want to invest in a company and the company have given all the document. Suppose if investor have not read the 10 points, for that thing company is not liable. It is a liability of investor that why he have not read the point. So that's why this is called constructive notice. So in constructive notice, this is the protection for the company, and indoor management, this is a protection of the investor, because in indoor management the company have changed the internal rules and regulations, and that rules and regulations they have not informed to the investor who just want to invest. So in indoor management, that's protect the investor. Prospectus is just like a brochure, so it's talk about the financials, or you can say the future plan of the company, that is called prospectus. Directors, member, so member have a statutory right that is written in the act, documentary right that is written in the document, and legal right that is a general right. If we talk about the winding up, so in the winding up, the company can be end by the help of tribunal, and company can be also end with a voluntary decision. That's it. Okay. Now if we talk about the maximum in private company, minimum 2, maximum 200. In a private company, the director minimum is 2, maximum 15. Public company, member minimum 7, maximum unlimited. Public company director minimum 3, maximum 15. One person company, member is minimum 1, maximum 1, director is minimum 1, maximum 15. So this is your total number of directors. So this is all about your Company Act. Now class RTI, we can seek the information from the Public Information Officer, which is appointed by the public authority. Whatever we are asked the information, it should be in writing. The fees will be only 10 rupees. Information should be come within 30 days and within 48 hours in the case of life and liberty of the person. Okay. First appeal, suppose sir is there, sort of sir. So first appeal within 30 days with the senior officer of CPIO. If we are not satisfied, then within 90 days we can file the case to the CIC. Okay. In the state level, it is SIC. Okay. And the Central Information Commission have to dispose the matter within 30 days up to 45 days. So up to 45 days they have to solve the matter. The punishment will be penalty will be 250 rupees per day, maximum up to 25,000 rupees. Very important term. It is just a quick revision that is benefit for all of you guys, all of you. So this is very much important. Okay, class. Cool. Now the next one is, it's a TP Act, Transfer of Property Acts. Let's revise the important terms. So first of all, the definition of mortgage is defined in section 58 clause A. That's talk about the definition of mortgage. When we give immovable property as a security, this is called mortgage. Is that okay? Simple mortgage 50. First of all, you have to read all the, you have to learn all the sections. Simple mortgage 58B, conditional 58C, usufructuary 58D, English mortgage 58E, equitable mortgage 58F, and anomalous mortgage 58G. So these are the types of mortgage. Is that okay? Now class, you can see here in the simple mortgage, no delivery of possession of property. If the mortgagor is not able to pay the money, the court will intervene. With the help of court, the mortgagee can sell the property. In conditional mortgage, the mortgage deed will be automatically converted into the sale deed if the mortgagor is not able to pay the money. Usufructuary, if mortgagor is not able to pay the money, mortgagee can use and take the rent from the profit. Okay. English mortgage, that is a combination of simple mortgage plus conditional mortgage. Okay. Equitable mortgage, basically we just give the title. This is the only mortgage where no registration is required. Okay. Anomalous mortgage, the different types of mortgage, or it is the combination of different types of mortgage. This is your anomalous mortgage. To the to the point, we are just studying everything. To the point. Okay. Next is IT Act. IT Act have taken the reference from United Nations Commission on International Trade Law. When IT Act come into picture, these four act is some changes happen in this one. IPC, Indian Evidence Act, Bankers Book Evidence Act, and Reserve Bank of India Act. Investigation, it should be done by inspector of police. Okay. Private key is basically to create the sign. Public key is to verify the sign. The act is for appointment of any officer not below the rank of director to the government of India who shall adjudicate the matter. So we can say adjudicate the matter. Okay. Then, so this is the first appeal. Suppose if we are not satisfied with the matter of adjudicating officer, we can just appeal to the appellant tribunal, and the appellant tribunal, they have to finish the matter within 6 months, and we can file the appeal to the appellant tribunal within 45 days. And appellant tribunal is telecom regulatory dispute, this one, telecom regulatory, that's the name of appellant tribunal. Okay, that is very important. See, then class LLP, it is a combination of partnership plus company, that is called LLP. It is a body corporate perpetual succession. It means if the partners will not there, the LLP will be go as it is. LLP also have a separate legal entity apart from the partners. They have a mutual agency. LLP agreement is the important document. They are also artificial legal person. They have also have a common seal, but in 2015 it is not compulsory. The partner's liability is limited. The management of business is in the hand of the designated partner. Minimum two, and maximum number of partner is unlimited. Okay. So this is important about your LLP. Okay. Now class, after LLP, Prevention of Corruption Act, special judge will be there who will appointed as a special judge who will just adjudicate the matter, appointed by central government and state government. Session judge will be taken as a judge, as a special judge. Okay. And the trial court have to conclude the matter within 2 years up to 4 years. That is very much important. Who will investigate? The police officer not below the rank of, if the place is Delhi, inspector of police. If the place is metropolitan areas, Mumbai, Kolkata, Madras, Ahmedabad, then assistant commissioner of police. And if the place is elsewhere, then the deputy superintendent of police will be there. Okay. The authority to examine the banker's book is police officer below the rank of superintendent of police. Okay. High Court, if you want to appeal and revision, you can just file the case to the High Court. Punishment will be minimum 3, maximum 7 years. Important point. Okay, then after a quick revision of module C, Lok Adalat, basically the Lok Adalat is given in Legal Service Authority Act 1987. If we talk about the justice, so they will just compromise and settle the matter. Jurisdiction, if any matter is pending before court, that matter can become in Lok Adalat. If one of the party make an application to the court, the matter can become into the Lok Adalat. If it is in the opinion of the court, if they think that the matter should be go to the Lok Adalat, the matter can become. Is that okay? If any person file the application to authority and committee, they can also send the matter to the Lok Adalat. The monetary compensation is up to 20 lakh. Whatever the justice is called award, that should be binding on all the party. No appeal after Lok Adalat, and the Lok Adalat have the same power just like the civil court. To the point things we are just studying. Is that okay? Then after Bankers Book Evidence Act. In the Bankers Book Evidence Act, suppose if the matter is about bank and customer, so the bank have to present the record which is maintained. So book is called the record. So the bank do not have to give the original copy. The certified copy of any entry, okay, shall be received as a prima facie evidence of the existence of such entry. And what is prima facie evidence? Prima facie is a legal word. It means on the face of it. On the face of it, okay? Suppose if bank is not a party in any case, so no officer of bank shall be compellable to produce any banker's book which can be proved under this act by the production of certified copy. Okay. Inspection of book by the order of court and judge. Okay. It should be made either with and without summon to the bank, and it should be served within 3 clear days. 3 clear days, that is a working days. Important point. Okay, then after Consumer Protection Act, okay, Consumer Protection Act. So class, in the Consumer Protection Act, we can say that customer, okay, this is a consumer, if he want to file the case in district commission, 2 year is the limitation period. If he want to file the case in state commission directly, 2 year is the limitation period, and directly in national commission, 2 year is the limitation period. From district commission to state commission within 45 days, from state commission to national commission within 30 days, and from national commission to Supreme Court within 30 days. From district commission to state commission, 50%, okay, pay, then he can appeal. From state commission to national commission, 50% he have to pay, then he can go to the national commission. Important point. Jurisdiction 2019 up to 1 crore, state commission 1 crore up to 10 crore, national about 10 crore. 2021 it is up to 50 lakh, state commission 50 lakh to 2 crore, national commission it is above 2 crore. Very important point. And the case can be filed where opposite party reside, where complainant reside, where cause of action taken place. Very important term. Is that okay? Then MSME, if we talk about the penalty for the first conviction, 1000. If it is again not less than 10,000. 1000 minimum, 10,000 maximum. If not follow the rules and regulation of section 20, then the fine up to 10,000 rupees. If we talk about the national board for MSME, 47 member, out of which 18 is ex officio member. Ex officio means who have holding the 2 posts. Advisory committee, the chairman of secretary ministry of MSME. Okay. For this one, 5 officers will be there, 3 representative of state government and 1 representative of micro small medium enterprise. This is very much important for the micro. Investment is up to 1 crore, turnover is up to 5 crore. Small, Investment up to 10 crore, turnover up to 50. Medium, investment up to 50, turnover up to 250 crore. The matter can be solved in facilitating counsel. The counsel also refer the matter to the arbitration. Sorry, first of all in conciliation. Within 90 days, they have to solve the dispute. If conciliation is not able to file the case, we can refer the matter to arbitration. Same, within 90 days, arbitration have to solve the matter. We can also refer to the court, but if we are referring or appeal in court, so 75% amount by appellant, and the appellant must not be the supplier. Very important term. Okay. Then after class, we have a IBC, that is a Insolvency Bankruptcy Code 2016. Four pillar, it's a Insolvency and Bankruptcy Board of India, as we can see here. Okay, the first, Insolvency Professional, then Information Utilities, and then Adjudicating Authority. So these are the four pillars of this one. The corporate insolvency resolution process have to be finished within 180 days. 90 days extra will be given if 66% voting of committee of creditor. Fast track, they have to finish the matter within 90 days plus 45 days extra will be given. Suppose if the default is of individual and partnership firm, DRT will solve the matter. DRT appellant and then Supreme Court. If the corporate person or LLP, the matter will become in NCLT, then NCLAT, then Supreme Court. That is very much important. Integrated Ombudsman Scheme 2021. These three acts has been removed and now one single act is made. The Banking Ombudsman Scheme 2006, the Banking Scheme for NBFC, and the Ombudsman Scheme from Digital Transaction. That is important. Compensation is up to 20 lakh and for mental agony, compensation is 1 lakh rupees. So, adjudicating authority will solve the matter. Within 30 days, we can appeal before the appellant authority, and the appellant authority is executive director. Important point. Appellant authority is class executive director. Okay. Then class, this is a limitation act. So limitation act, as we can see that basically it's a 3-year is the limitation for every act, and what you have to learn, that is 12-year, that is for the mortgage, 30-year for the foreclosure, and 12-year for the possession of immovable property. See, then after we have a, again these are the important terms. So in the whatever I have just highlighted, just learn these terms for execution of decree, for lower court to high court appeal, and for a lower court to other court appeal. So this is the important term. Now class, if we talk about DRT and DRAT, so when this act is come into picture, so the case was filed whether this act is valid or not. So when Union of India versus Delhi High Court Bar Association, Supreme Court say that this act is totally valid. DRT, central government appoint presiding officer. Presiding officer should be qualified as a district judge. Tenure is 5 year and 65 year. If they want to resign 3 month prior notice, or central government can also remove by misbehavior and incapacity. DRAT, central government appoint chairperson as a head of DRAT. The qualification is qualified to be the judge of High Court, or Indian legal service at least 3 year, or presiding officer at least 3 year. Tenure 5 year plus 70 year, and 3 month prior notice if they want to resign. Okay. Then the presiding officer will issue the recovery certificate. Okay. If there's any mistake, it should be done by presiding officer only. Suppose if you want to review the order passed by tribunal and the recovery certificate issued by tribunal, so within 60 days you have to file the appeal. DRT to DRAT within 30 days file, and 50% you have to pay, then you can appeal. Within 6 months they have to finish the matter. Okay, and the bank and financial institution, they have to file the case within 3 years from the cause of action. Very important point. Done, class? Then it's a SARFAESI Act. So SARFAESI Act, again, when this act come into picture, it's a Maria Chemical Union of India case in which it was held that this act is totally valid, except section 17 clause 2, in which it was said that 75% amount pay. So this is removed. If anyone contravene the provision, 1 year is a punishment plus fine plus both. Metropolitan Magistrate and Judicial Magistrate of first class, if the complaint is filed by Officer of Central Registrar or Officer of Reserve Bank, then they can also take the cognizance of case. Penalty will be if not following the rules and regulations of Reserve Bank of India. So up to not exceeding 1 crore, okay, if the amount is not quantifiable, and twice the amount if the amount is quantifiable, that is calculated. Continue, then 1 lakh rupees per day. Adjudicating authority will solve the matter. Within 30 days, you can go to the appellant authority, and appellant authority should be Central Board of Reserve Bank. Act is not applicable to the lien, pledge, any vessel, conditional sale, hire purchase, unpaid sailor, properties not liable for attachment, up to 1 lakh rupees, etc. Okay, so this is very much important. So again, class, it's a quick version of module B. RBI have a power under FEMA to appoint the authorized person and to inspect the authorized person. Under the FEMA, any violation, okay, if you any violate the FEMA, then right to arrest and detention. If you not follow the guidelines of RBI, thrice the sum if the amount is quantifiable, and if the amount is not quantifiable, 2 lakh rupees. If you do continue, 5,000 rupees each day. Then assistant director who will just investigate the complaint. Dispute is resolved by adjudicating authority. Then special director is the first appeal and appellant authority is the second appeal. If there is a question of law and interpretation of law, then we can file the case to the High Court and Supreme Court also. And ED is there for the investigation. Okay. Then class, Prevention of Money Laundering Act. First of all, the term money laundering is not defined in Prevention of Money Laundering Act. Punishment is minimum 3, maximum 7 years. Maintenance of record above 10 lakh, we have to maintain the record. For the cross-border wire transfer, more than 5 lakh. For or the purchase of immovable property, it is 50 lakh and more. If the individual is going for transaction, then the regulated entity have to see the valid document containing details of identity, address, one recent photograph, such other document. If client is a company, certificate of incorporation, memorandum and article of association, resolution from board of director, power of attorney, officially valid document, etc. If client is a partnership firm, registration certificate, partnership deed, officially valid document, etc. If client is a trust, registration certificate, trust deed, officially valid document, etc. Okay. Negotiable Instrument Act, you have to learn these section 4, 5, 6, 8, 9, 10, 138. 4. Promissory note, 2 parties. Drawer, pay. Bill of exchange, drawer, drawee, pay. Check, drawer, drawee, pay. Holder, holder in due course. In holder in due course, you can file the case for money, but in holder, you cannot file the case. Payment in due course, good faith without any negligence. Section 138 talks about dishonor of check. Punishment is 2 years and twice the amount. 143A, it's talk about interim compensation. Okay. Interim compensation is interim compensation is 20% of the amount of the check. Within 60 days, you have to give up to 30 days. 30 days extra will be given. If the drawer the check is acquitted, then the complainant have to repay the amount. Okay. 138, appeal filed by drawer against conviction. So again, if we want to file the appeal, 20% he have to pay. Grace day 3 and acceptance of bill of exchange is 48 hours. Payment and settlement, it is regulated by Reserve Bank of India and the Board for Regulation and Supervision of Payment and Settlement System. For gross settlement, RTGS, net settlement, EST credit, ECS debit, NEFT, UPI, etc. It is the Reserve Bank shall exercise the power function through the Payment Regulatory Board. And in the Payment Regulatory Board, governor, deputy governor, 1 officer, 3 person will be there. That is the total number of members. That is the total number of member. Important point. Then mortgage, section 58 we have already done. Okay, section 58A. Clayton rule, that is given in Indian contract, section 59, 60, 61. It is also called FIFO, first in, first out. Oh, it is called setting aside the fund. Assignment, process by which a person called assigner transfer the right and benefit to the another person. Hypothecation, section 2 clause N. Okay, possession and ownership is with the borrower without delivery of possession to the movable property. Lien, that's the absolute right of banker lien. 171 of the Indian contract talks about the journal lien. Set off, enable him to adjust the debit balance in a customer account. That is called set off. So these are the rights of the bank. Then class module A. Two act is there, Banking Regulation Act and Reserve Bank of India Act 1934. Section 42 talks about cash reserve ratio 1934. Section 5B, banking definition. Section 22, license. Qualification of director, 51% of the total number of directors shall be the person who have a special knowledge and practical experience with accountancy, agriculture, rural economic, banking. 21 talks about control of loan advance. 26, unclaimed deposit, that is also known as DEF account. 35A talks about the RBI to give direction to the bank and can take action. 35A talks about banking ombudsman scheme. Important point. Balance sheet profit loss, it should be signed by the manager and principal officer. Okay, at least 3 directors. And in the case of foreign bank, the agent of the principal officer of India can sign. 3 copies we have to submit to the Reserve Bank of India. Winding up, we can apply to the High Court. Establishment of RRB, central government 50%, state government 15%, sponsor bank 35%. Okay. NBFC, more than 50% stake is in the hand of government. It's a nationalized bank. FSDC, C, the chairperson, established by government, chairperson, finance minister, and member are the head of RBI, SEBI, PFRDA, IRDA, FMC. Subcommittee, chairman is governor, RBI. Working group, it's a inter-regulatory technical group on financial inclusion and financial literacy. Inter-regulatory forum for monitoring financial conglomerate, early warning group, working group on resolution regime for financial institution. See, and micro financial monitoring group is there, that is chaired by the chief economic advisor. So class, that's all for today's. It's a marathon, and all the best for everyone for the exam. Okay, thank you so much.